All right, court is calling 2021 CR 1907, State of Texas versus Vanessa Rosano. Could I have parties announced for the record for the state,
Please raise your hand, Your Honor.
for the defense?
Monica Corolla.
Are you Miss Rosano? Going to show you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review this document
Yes, ma'am.
with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Vanessa Rosano who was placed on deferred adjudication in 2021 CR 1907 for the offense of theft of aluminum, bronze, copper, brass on March 1st, 2022 for a period of 2 years? Is that you? Oh, no problem.
A Texas courtroom becomes emotional after a grandmother on probation admits to using methamphetamine while caring for her 2-year-old grandchild. The defense asks Judge Stephanie Boyd for another chance, hoping probation, drug court, and treatment can keep her out of jail. But the judge says the long list of probation violations proves one thing: nothing has changed. Now the grandmother faces a brutal choice: prison or strict supervision. And when the judge hears a small child may still be living inside the home, the entire courtroom suddenly turns serious.
State?
I'm sorry, Judge. Can you
That's
just
okay,
have a moment?
sure.
Violated condition number 2 on or about the 31st day of October 2022 in Bexar County, Texas. The defendant Vanessa Rosano did then and there legally use a controlled substance, namely methamphetamine, in violation condition number 2.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining violated conditions.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to deny the motion to adjudicate guilt, continue on her deferred, extend for 18 months, refer to felony drug court, also have GPS for 3 months, also weekly UAs, also parenting classes, also report 2 times a month, or in person or in Zoom, Your Honor. And that would be the agreement.
Are you asking the court to follow that agreement?
I am, Your Honor.
Are you asking the court to follow that agreement? The fact that the state is asking so much of you and probation is asking so much of you tells me you've done nothing. So I'm going to give you a choice because I don't know if you're going to be successful or not, but it appears that you have done nothing. And I'm looking at the docket sheet, and at the docket sheet, at first, this was supposed to be a pretrial diversion. And all you had to do was pay $547 for that to be done. And then we've had a motion that has been filed before and that has been withdrawn. And now we're back here. So here's your choice. I can extend you for 2 years. I'm not going to extend you for 18 months. I'll extend you for 2 years. Or either I'll sentence you to the state jail facility for 18 months. You'll complete it. You'll be done. You can do what you want to do with your life. Otherwise, I'm going to continue you and I'm going to follow these recommendations.
And my choices, what was the previous?
18 months in the state jail facility, or either you're going to be extended for 2 years. There'll be a referral to felony drug court. You're going to remain in custody till felony drug court accepts you. If felony drug court does not accept you, you're going to safety. So which would you prefer?
The second, the 2 years instead of the 18 months.
Okay. All right, the court will deny the motion, alter the main conditions to include a 2-year extension, a referral to felony drug court. If not accepted, then safety. And this is all to be done in custody. Parenting classes, there's to be no unsupervised contact with minors. There is to be partial GPS for employment only. No employment as a home health care provider or with minors. The UA hotline until further notice, and field visits 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
Your Honor, if I could just provide the court with a little bit of information with regard to the parenting class
Yes.
that's been added as a condition. Ms. Rosano has a 2-year-old grandchild in the house where she lives. She has a 24-year-old son who suffered from significant mental health issues last year, which is how Ms. Rosano ended up caring for his child. He has gotten the mental health assistance that he needs. He's on medications and he's actually gainfully employed and living outside of Ms. Rosano's home. However, the grandchild still does reside with her and she is charged with taking care of him. This is something that she volunteered to do as a grandparent. It was her responsibility and her heart to do that. The unsupervised visitation that the court just imposed as a condition of that probation. In light of those circumstances, I was wondering if you'd reconsider the unsupervised visits that you impose. It has nothing to do with any dangerous conditions in her home that she has created. I do understand she has a positive or an admission to using methamphetamine in 2022. However, that was prior to her having a grandchild. So I don't know if the court would reconsider unsupervised
Well, let me
visitation.
ask this. Has she been reporting? I know that's an allegation in the motion, but there was no plea of that. So has she been reporting?
Correct. That was, she has not been reporting, which is why we suggested a GPS for 90 days to get her back on.
Has she
track.
done any, since she hasn't been reporting, that means that she hasn't done any UAs. Am I right in assuming that?
I believe that would be a safe assumption.
All right. So I don't know if she's using meth or not, but I do know if you're using meth, you shouldn't be babysitting anybody's grandchild,
True, I agree.
right?
And
All right. So that's where we are. There's to be no unsupervised contact. And I don't know if Child Protective Services are involved or not. They probably should be. If the option is your son has mental health issues, so he should not be alone with the 2-year-old, and then you're using meth. That's not a good combination for either parent for a child if your son is not on his medications.
my son, he's taking Zoloft, he's been taking Zoloft for almost half a year now.
All right. So then that's where we are.
Yes, Judge.
All right. Thank you.
Thank you.
Thank you, Your Honor.
All right, if you need anything, you feel as though probation is not addressing the issue, you can always come back to the court. Do you understand? All right, thank you. Ray Espinoza.
This hearing was not only about probation violations. It quickly became a conversation about responsibility, addiction, and the safety of a small child. Judge Stephanie Boyd listened as the defense explained that Vanessa Rosano had stepped in to help raise her 2-year-old grandchild after her son struggled with mental health problems. But the judge focused on something else: repeated failures on probation and an admitted methamphetamine violation. The court heard that Rosano had stopped reporting to probation and had not been completing drug testing. That made the judge question whether anyone could truly know if the drug use had stopped. Instead of immediately sending her to state jail, the judge offered another opportunity through felony drug court and treatment programs. But the conditions became extremely strict, including GPS monitoring, parenting classes, drug testing, and no unsupervised contact with minors. The moment showed how quickly addiction cases can become bigger than one person, especially when children and family responsibilities are involved. Do you think Judge Stephanie Boyd made the right decision by giving probation another chance instead of sending her to jail immediately? Or do repeated probation violations mean the court should stop offering second chances?